Justice Scalia had an interview with the California lawyer. And during the interview, he was asked about the 14th Amendment. So I want to read you guys the question, and then I want to read you, the relevant part of his answer, because it was a very long answer. So the question was, in 1968, when the
1868.
I'm sorry, 1868, when the 39th Congress was debating and ultimately proposing the 14th Amendment, I don't think anybody would have thought that equal protection applied to sex discrimination, or certainly not to sexual orientation. So does that mean we've gone off in error by applying the 14th Amendment to both? So Scalia's answer was, yes, sorry to tell you that, but if indeed the current society has come to different views, that's fine. You don't need the Constitution to reflect the wishes of the current society, which I agree with. Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that that's what it meant. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures and they enact things called laws. So I could see how someone would agree with him, right? The Constitution, especially the 14th Amendment, is so broad. It doesn't specifically say anything, right? So, and
no, it says something, but
well,
I hear what
it
you're
does,
saying.
but
It doesn't. What you're saying is it doesn't specifically say, "Hey, this should apply to only blacks or to women or to Latinos or whoever else."
It was vague for a reason, right? So, but his argument is that that amendment doesn't apply to women at all. That's what I took away from his answer.
That is his argument.
Yeah,
That's right.
And he says it doesn't apply to women at all, but that's okay because under our political system, people can vote on things so women don't get discriminated against.
Right, if they want to, or if they can't, if they want, according to Scalia's logic, and this is absolutely the case.
So what about the Equal Protection Clause? Does that mean anything at all? The Equal Protection Clause doesn't specifically mention men.
That's what he's talking about, yeah. That's the 14th Amendment.
But that doesn't make any freaking sense. The Equal Protection Clause doesn't mention anyone specifically.
Well, it was done in regards to slavery, right? And it was, the 13th, 14th, and 15th Amendments were to free the slaves, and they were saying, hey, listen, they get equal rights as everybody else does, okay? Now, they wrote it vaguely, just as you say, the equal protection of the laws, etc. And Scalia is saying, yeah, they meant black people. They didn't mean women, okay? So if Alabama, I'm just picking a random state, or California or anyone else wants to say, hey, you know what, women don't have the same rights. They can do that. They can say, hey, you know what, sad day for you. You'll make 50 cents when a guy makes $1, as an example.
Here's what my argument to that is. If they were specifically referring to black people, then that Equal Protection Clause would say black people. But it didn't say that because, the Founding Fathers wanted to leave it as vague as possible.
That's a great point. Scalia would counter by saying, look, at the time, nobody thought that it applied to women. It didn't apply to women at the time. Women got the right to vote, for example, many years later, many decades later, right? It certainly didn't apply to sexual orientation, right? That didn't happen until, recently as well, vaguely speaking. Anyway, so look, I'm conflicted on this, right? I think that there is an interesting legal case to be made, and remember, I'm old school judicial conservative, right? Now, but back in the day, I used to believe that these guys were for real, that they were strict constructionists, and that they were principled. Now, I've been disabused of that very naive notion. Scalia has, on a million occasions, violated this principle over and over again.
Yes.
Don't make me list the dozens of cases. Let me just give you the most recent, Citizens United, where Scalia overturned 100 years of precedent to say, oh, no, corporations can give unlimited campaign donations, okay? But it's not just 100 years of precedent that he overturned and hence making him an activist judge, right? But the original Founding Fathers hated big money. They were scared to death of the big banks. They were scared to death of big business. Read the Federalist Papers, read their intentions. It is abundantly clear. If you told Madison and Jefferson corporations will be human beings and have the rights of human beings, they'd have been like, are you effing kidding me?
Yes.
Jefferson might have shot you, okay? So no, you don't talk about the interpretation of the people who wrote the document. What a joke you are, Scalia. What a clown you are.
Yeah,
okay?
I think that staunch conservatives like Scalia, interpret the Constitution when it comes in favor of whatever their beliefs are.
Whatever their political and religious
Exactly.
beliefs are,
Yes.
no question. So Scalia's a joker. Now, putting that aside, look, the question is what balance do you reach, right? Because if you say, hey, equal protection, and I could mean X by it, I could mean Y by it, and I'm going to let the courts decide. I start to get a little concerned, right? But at the same time, if you say, no, you only can take the intention of the people who voted on it in 1868, right? That's also way too narrow and unacceptable, right? So the question is how you balance that, and that's a really tough question if you ask me. Now in this case, it's so broad that you could even say the intention was for them to, they wrote it broad on purpose, as you said, and that it would get expanded, and many of the rights we have under the Constitution had been expanded by the time they reached 1868. So it's not like the legislators didn't see that coming, right? So for the Equal Protection Clause, which is immensely broad to be applied to women and other minorities, of course.
It's a no-brainer.
Of course, I think it's a no-brainer, right? And so Scalia is being disingenuous here. But one quick, personal note on this: I think the 14th Amendment is broader than most people think it is, right? In this case, and I don't know why they draw the line at me. Okay, I'll tell you why. Not because I'm Turkish or Muslim or anything like that, right? But everybody says you have to be born here in the United States to become president. Why? Because that's in the Constitution. It is. But the amendments amend the Constitution, okay? And the 14th Amendment said that we all have equal protection of the law, right? And that we all get due process, et cetera, et cetera. So if that amended the Constitution to give me equal protection, why does it apply to me then to say that I don't have the same rights as other citizens to run for office?
Yeah. I actually agree with you on that.
Now, I ran that by my constitutional law professor back in law school. And here's what he said. I never thought of that. Right? And he's like, well, that would be a unique argument, Mr. Uger. My guess is your chances would be very low. Based on just the fact that they haven't done it before and no cases really come up. So that's
no one's really put any thought behind that before.
Right. But I'm just saying, I'm not saying anything. Imagine you tell Scalia that. He's like, no!
So are you planning on running for office? Is that what?
I'm not saying anything. By the way, I can run for office, just can't run for president.
Right.
Okay, no, I'm not going to. But imagine me running for office. The negative ads they'd have on me.